It's distorted the intricate checks and balances the framers believed were essential to the success of the American experiment. As the ultimate and unappealable arbiters of the Constitution, the justices of the Supreme Court have become far more than the referees in constitutional disputes that the framers intended. They've gone beyond interpreting the rules. They've come to create them. From John Marshall to John Roberts, as the court has evolved from its makeshift quarters in New York City, the nation's first capital, to its imperial courthouse in Washington, D.C., the justices have so successfully enlarged and consolidated the power of judicial review that they've become, in effect, and often explicitly, lawgivers. And unlike the President and members of Congress, the policymakers on the court don't face the judgment of the voters for their actions. They're never held politically accountable to the American people. But neither has the Supreme Court been above politics. Most justices have been political activists, party politicos, before joining the court. Many have owed their elevation to party ties as a reward for loyalty, with every expectation that they won't turn coat on the court. Justices might shed party labels when they take their seats on the bench. Newspapers don't print R or D after their names when reporting decisions. But with some notable exceptions, they don't abandon their party doctrines. Instead, they become politicians in robes. No sooner did Americans begin to fashion the first political parties in the 1790s than the Supreme Court became a magnet for partisan conflict. From George Washington to George W. Bush, the opportunity for presidents to pack the bench with loyalists and so gain political and ideological control of this potent third branch has been irresistible. In this book, I use the term packing in this general sense, to refer to the deliberate effort by the party in power, sometimes across several administrations and over decades, to use the presidential prerogative of appointing justices to ensure domination of the Supreme Court by its own partisans. Court packing has been abetted by the life tenure the Constitution gives justices. The average tenure of Supreme Court justices since the nation's founding has been more than 15 years. Since 1970, it has increased to more than 26 years. Justices throughout the court's history have clung to their seats long after their political patrons have retired, and long after their parties have yielded to their opponents or even disappeared. They have often perpetuated ideologies and attitudes that are outdated or that Americans have repudiated at the ballot box. Inevitably, life tenure has produced a critical time lag, with the Supreme Court institutionally almost always behind the times. As a result, too often, the Supreme Court has seemed to be fighting the progress of history. The terms of elected officials are predictable, fixed by the Constitution. As of today, we know that, barring catastrophe, in 2020 or 2056, say, candidates for the presidency and Congress will be facing the judgment of voters. But the Supreme Court selection process is by nature unpredictable and erratic, America's biggest wheel of fortune, with high stakes but uncertain payoffs. Everything depends on what justice may die or retire, when, and with what party controlling the presidency and the Senate. A one-term president like William Howard Taft may pack the Supreme Court with as many as 6 appointments and retain an influence there for decades, even though he loses re-election by a landslide. Another one-termer like Jimmy Carter may leave no justices behind him. Over the years, this judicial roulette has produced a jagged line of personal and political selections that made what might have been the most stable of branches the most unstable, as well as the most unrepresentative of all the people. The American constitutional system has no lack of obstacles to transforming leadership.